ಹಲೋ ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆನಾ? ಯಾರು ಇಲ್ಲ ಅಂತ ಲೈಕ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಅಷ್ಟಿದ್ರೆ ಸಾಕು. 873136 ಅಷ್ಟೇ. ನಾನೇ ಕನೆಕ್ಟ್ ಆಗಿದ್ದೀನಿ. ಯಾರು ಕನೆಕ್ಟ್ ಆಗಿದ್ರೆ ಕೇಳ್ಬೋದಿತ್ತು. ಸೀತಾರಾಮರು ಕನೆಕ್ಟ್ ಆಗಿದ್ರು, ಡಿಸ್ಕನೆಕ್ಟ್ ಆಗಿದ್ರು. ಇಲ್ಲಿ ಇವಾಗಿರ್ತೀನಿ ತಕ್ಷಣ ನೆಟ್ಟಿಗಿಂತ ಅಷ್ಟೇ. ಆಯ್ತು. ಯಾರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ. ಇದನ್ನೇ ಹಾಕಿದ್ರ ಆಯ್ತು. ಅದು ಈಗ ಇರ್ಬೇಕು. ನಾನು ನೋಡ್ತೀಯಾ? ಯಾರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ. ಬಂದಿದ್ದಾನೆ. ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆನಾ? ಫ್ರಮ್ ಕೋಟಲ್ ನಂಬರ್ 9 ಚೈತನ್ಯ ಕುಮಾರ್ ಸರ್. ಸರ್ ಮಾತಾಡಿ.
ಕೇಳಿಸುತ್ತೆ ಮೇಡಮ್.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಟಚ್ ಆದ್ರೆ ಎಲ್ಲಿದಾಗುತ್ತೆ? ಕೇಬಲ್ ಟಚ್ ಆದ್ರೆ ಹೊಟ್ಟೋಗ್ತಾ ಇದೆ.
ಇಲ್ಲಿ ಫೈಲ್ಸ್ ಇಡ್ಬೇಕಾದ್ರೆ ಕೋರ್ಟ್ ಆಫೀಸರ್ ತಿರುಗಿಸ್ತಾರ. ಕೋರ್ಟ್ ಆಫೀಸರ್
ಇನ್ನು ಬಂದಿಲ್ಲ ಸರ್, ವೇಟ್ ಮಾಡಿ.
ಅಲ್ಲ ಮೇಡಮ್, ಗುಲ್ಬರ್ಗ ಬೆಂಚ್ ಫಸ್ಟ್ ಕರೀತಿರಲ್ಲ ಮೇಡಮ್?
ಫಸ್ಟ್ ಕಲಬುರ್ಗಿ ಇದೆ.
ಆಯ್ತು, ಥ್ಯಾಂಕ್ ಯು.
ಸಾಹೇಬರಿಗೆ ಕೇಳಕ್ ಹೋಗಿದ್ದಾರೆ.
ಆಯ್ತು ಮೇಡಮ್.
ಓಕೆ ಓಕೆ.
ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್?
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಓಕೆ ಸರ್. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಸರ್? ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ಗೊತ್ತಾ ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಮಿಸ್ ಆಗಿತ್ತು, ಕರೆಕ್ಟ್ ಆಗ್ತಿರ್ತದೆ. ಅವ್ರಿಗೆ ವೇಟ್ ಮಾಡಿ. ಅಲ್ಲ ನಾನ್ ಫೈಲ್ ಆಗ್ತಿದೆ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ, ಅವ್ರು ಕಳಿಸ್ತೀವಿ, ವೇಟ್ ಮಾಡಿ. ಮಾಡಿ ಹೌದು
ಹಲೋ, Sir, first Kalburgi bench idu one matter ಇದೆ sir.
Matter pertaining to Kalburgi bench, cell number 1.
1 minute.
Milord, I am praying for the petitioner in this matter.
Present matter.
Present matter. Yes.
Cell
Yes.
number 1, Chandra. Chaitanya
Milord, I am
Kumar
praying for the petitioner in this matter, Milord.
Yes.
That will not reflect kindly.
Milord, this is successive bail petition.
1 minute.
I have served it on the.
Serve copy to other
I
side.
have sent it to my. I have sent it. And the acknowledgement is also filed with the objections.
Yes, please.
My lord, this is successive bail petition. My lord, initially on the FIR, my lord, this petitioner has approached this honorable court in my lord criminal petition 2000425/2022, which came to be rejected by this honorable court on my lord 20th April 2022. My lord, after filing charge sheet, my lord, initially name of the petitioner was not there in the FIR. My lordship may kindly see my lord ink page 14. My lord, where allegation is that my lord the complainant and my lord the family members went to the my lord house of Munnu, accused number 1, my lord, for asking the my lord share in the property. Then my lord he abused my lord deceased Shantabai, saying that my lord he will not give any share. For that that my lord she herself has my lord consumed poison, and my lord she shifted to hospital where my lord she has died on my lord 3/2/2022. My lord, after death of Shantabai, further statement of complainant is recorded, my lord, on 4/2/2022. My lord, same my lord said statement is my lord I have filed on 6/4/2023, which is sent to my lord your lordship, my lord. It is there on record, my lord. My lord, where my lord in the first instance it is specifically alleged that my lord she herself has consumed poison, as a result of which my lord she has my lord admitted to the hospital where my lord she has died. After death of my lord Shanti Bai on 4/2/2022, further statement of my lord complainant is recorded.
When did deceased die?
My lord, she has died on my lord 3/2/2022 at 7:30 p.m. My lord.
Whether the complainant is an eyewitness to the incident?
Please, my lord. According to my lord statement, he is an eyewitness to the incident, my lord. And other two persons were my lord eyewitness to the incident. My lordship may kindly see my lord ink page 14. My lord
40.
Sakshi Bai Ganda Lakshman, Dev Bai Ganda Polsing. My lord, according to complaint, they my lord specified the my lord quarrel. My lord, in the charge sheet, my lord, they have not been shown as my lord charge sheet witnesses. And my lord, in the further statement.
1 minute.
Please.
Whose statement at which ink page? Ink page 14 or 14 or 40?
14 is my lord complainant, my lord.
Yes. You said another eyewitness.
My lord, witness, my lord, in the complaint, two names are mentioned, my lord. Paragraph 2, my lord.
Yes.
May I read, my lord?
Sakshi Bai.
Please, my lord. Sakshi Bai and another Devi Bai Ganda Pulsing.
Where is their statement?
My lord. There, my lord, specified the my lord quarrel.
At which page is the statement of Sakshi Bai and Devi Bai?
My lord, their statement has not been recorded, my lord. They are not shown as eyewitness, charge sheet witness, my lord.
Where is the charge sheet at which page?
My lord, charge sheet is, my lord, ink page 24, my lord. My lord, witness is, my lord, at ink page 26, my lord.
In page 14, is it the complaint or a statement?
Yes, my lord. Complaint, my lord. Further statement of the complainant is recorded on 4/3/2022, my lord. That is, my lord, I have sent, my lord, on 6/4/2023, my lord. Further statement of the complainant, my lord.
1 minute. Yes.
My lord, further, according to further statement, my lord, the version is changed, my lord. It is alleged, my lord, since, my lord, they demanded property, then, my lord, he said they are not related to the complainant, the accused number 1, and, my lord, they abused, and, my lord, he asked, my lord, accused number 12 to, my lord, bring poison, and, my lord, accused number 1 and this petitioner, accused number 8, forcibly, my lord, put the poison on the mouth of, my lord, deceased Shantabai. As a result of, my lord, which, my lord, she sustained, my lord, she has become ill, my lord, and she shifted to hospital where she has died. May I read, my lord, relevant portion, my lord, which is made allegation against this petitioner?
Yes.
My lord, relevant portion is, my lord, ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆ, my lord, in the first paragraph, my lord.
First paragraph.
Typed copy, my lord.
First paragraph of what?
Further statement of Akash, my lord.
Yes.
Recorded on 4/2/2022.
Yes.
ರವಿವಾರ ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಮ್ಮ ಚಿಕ್ಕಪ್ಪ ಮುನ್ನ ಪವರ್ ಈತನು ನಮಗೆ ತಿಳಿಸಿದ್ದೇನೆಂದರೆ 11 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಮ್ಮ ಮನೆ ಕಡೆಗೆ ಬನ್ನಿ ಆಸ್ತಿ ಬಗ್ಗೆ ಕುರಿತು ಮಾತನಾಡೋಣ ಅಂತ ಹೇಳಿದ್ದರಿಂದ ಅಂದು ಬೆಳಿಗ್ಗೆ 11:30 ಗಂಟೆ ಸುಮಾರಿಗೆ ನನ್ನ ತಂದೆ ಹರಿಶ್ಚಂದ್ರ, ನನ್ನ ತಾಯಿ ಶಾಂತಿಬಾಯಿ ಇಬ್ಬರು ಕೂಡಿ ಅವರ ಮನೆಗೆ ಹೋದಾಗ ಮುನ್ನಾ ಪವರ್ ಈತನು ಸುಳಿ ಮಕ್ಕಳೇ, 2 ಮಕ್ಕಳೇ, ಏನ್ ಆಸ್ತಿ ಕೇಳಕ್ಕೆ ಬಂದಿರಲ್ಲ, ನಿನಗೆ ನೀವು ಸಂಬಂಧವಿಲ್ಲ ಅಂತ ಅವಚ್ಚವಾಗಿ ಬೈದು ಅಲ್ಲೇ ಇದ್ದ ಮುನ್ನಾ ಪವರ್ ಮಕ್ಕಳಾದ ಪ್ರೇಮ, ಅನಿಲ್, ಕಿರಣ್, ಭರತ್, ಮನ್ನು ಹೆಂಡತಿಯಾದ ಶಾಂತಿಬಾಯಿ ಮತ್ತು ಮನ್ನು ಪವರ್ ಸಂಬಂಧಿಕರಾದ ಹೀರಾ ಸಿಂಗ್, ತಂದೆ ಭಾಷಾ, ಎಸ್ ಹೊಸಳ್ಳಿ ತಾಂಡ ಮತ್ತು ಅವನ ಹೆಂಡತಿಯಾದ ಚಾಂದಿಬಾಯಿ, ದಿಸ್ ಇಸ್ ಮೈ ಲಾರ್ಡ್ ಪೆಟಿಷನರ್ ಅಲಿಯಾಸ್ ಚಂದ್ರಕಲಾ, ಇವಳ ಮಕ್ಕಳಾದ ರಾಜು, ವಿಕ್ಕಿ, ವಿನೋದ್, ಪ್ರಕಾಶ್ ಮತ್ತು ರಾಜು ಇವರೆಲ್ಲರೂ ಕೂಡಿ ನನ್ನ ತಾಯಿಗೆ ಕೈಕಾಲು ಹಿಡಿದು ಜಗ್ಗಿ ಹಿಗ್ಗ ಮುಗ್ಗ ಎಳೆದಾಡಿ ಕೆಳಗಡೆ ಬೀಳಿಸಿ ಸುಳಿ ಮಗನಿಗೆ ಖಲಾಸ್ ಮಾಡಿರಿ ಕಿರಿಕಿರಿ ತಪ್ಪುತ್ತದೆ ಅಂತ ಬೈದು ಆಗ ಮನ್ನು ಪವರ್ ಈತನು ಎಣ್ಣೆ ತಗಂಬಾಲೆ ರಾಜು ಎಣ್ಣೆ ಕುಡಿಸಿ ಕಲಾಸ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದಾಗ ಆತನ ಮಾತಿನಂತೆ ರಾಜು ಈತನು ಮನೆಯಿಂದ ಎಣ್ಣೆ ಔಷಧಿ ತಂದನು. ಎಲ್ಲರೂ ತನ್ನ ತಾಯಿಗೆ ಕೈಯಿಂದ ಹೊಡೆಬಡಿ ಮಾಡಿ ಆಕೆ ಒದ್ದಾಡದಂತೆ ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡಾಗ ಮನ್ನು ಪಾವರ್ ಮತ್ತು ಚಾಂದಿಬಾಯಿ ಇವರಿಬ್ಬರು ನನ್ನ ತಾಯಿಗೆ ಒತ್ತಾಯ ಪೂರ್ವಕವಾಗಿ ವಿಷ ಕುಡಿಸಿರುತ್ತಾರೆ. ಈ ಎಲ್ಲ ಘಟನೆ ದೂರದಿಂದಲೇ ನೋಡಿರುತ್ತೇನೆ. ನಮ್ಮ ತಾಯಿ ಕೆಳಗಡೆ ಒದ್ದಾಡಿ ಬಿದ್ದಾಗ ಓಡಿ ಬಂದು ಆಗ ನಮ್ಮ ತಾಯಿ ಬಾಯಿಯಲ್ಲಿ ವಿಷ ಮತ್ತು ಬುರುಗು ಬರುತ್ತಿತ್ತು. ಈ ಘಟನೆ ನೋಡಿ ನನ್ನ ತಂದೆ ನಿಸ್ಸಹಾಯಕವಾಗಿ ಬಿದ್ದಿದ್ದನು. ಆಗ ನಾನು 108 ಆಂಬ್ಯುಲೆನ್ಸ್ ಫೋನ್ ಮಾಡಿದೆನು. ಸ್ವಲ್ಪ ಸಮಯದಲ್ಲಿ ಆಂಬ್ಯುಲೆನ್ಸ್ ಸ್ಥಳಕ್ಕೆ ಬಂತು. ಆಗ ನನ್ನ ತಾಯಿಗೆ ವೈದ್ಯಕೀಯ ಉಪಚಾರ ಕುರಿತು ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆಗೆ ಯಾದಗಿರಿಗೆ ತಂದು ಸೇರಿಕೆ ಮಾಡಿದ್ದು ಇರುತ್ತೆ. Lord, what has happened, my lord? The deceased, my lord, deceased is my lord stepmother of the my lord petitioner. My lord, the Harishchandra has my lord 2 wives. First wife, my lord Gangibai, and deceased is my lord second wife. And this Chandibai is my lord the wife, daughter of first wife. She had filed my lord original suit against my lord father of my lord complainant. That is my lord CW8. My lord, for seeking partition, which is pending for consideration. My lord, I have produced my lord original suit filed by my lord this petitioner. For that reason, my lord, falsely this petitioner, as well as my lord, all my lord children of the my lord petitioner have been falsely implicated in the proceedings, my lord. My lord, original suit filed by my lord petitioner and Gangibai against my lord CW8 is at my lord ink page 47, my lord. 99, my lord.
Yes.
For this, my lord, the petitioner has been, my lord, falsely implicated in the proceedings, and my lord, she has been arrested by the police on my lord 8/2/2022, my lord. Since then, my lord, she is in custody.
Means when she is in custody?
My lord, since my lord 8/2/2022, my lord.
Yes. Yes, respondent. Yes.
The contention may not now raised by the petitioner, my lord, was already considered by this honorable court, my lord. If your lordship would kindly see page number 6 of the earlier
Yes.
page number 6, my lord.
Yes.
My lord, your lordship have already considered, my lord. That is, my lord, a bare reading of the complaint, though initially go to show that initially there are some altercations between the parties. As such, the accused person said to have, apart from abusing the parents of the complaint, also shown to have manhandled them and assaulted them. However, turn to the alleged allegations have come subsequent to the very complaint, giving his further statement before the police on 4/2/2022. In his said statement, he has specifically stated that the accused, apart from assaulting his parents, have forcefully administered poison to his mother Shantabai. My lord, earlier, my lord, FIR, my lord, is only an encyclopedia, my lord. My lord, the police, after my lord investigation, and my lord, after recording the statement of the witnesses, my lord, have filed the charge sheet, my lord, wherein, my lord, the column number 17 of the charge sheet, my lord, clearly reflects the overtax of the petitioner here, my lord. And my lord, column number 17, my lord, is consistent with, my lord, the PM report, my lord, that is at PM report, my lord. Sorry, my lord, my copy was not paginated, my lord. If my lord, if my I may be permitted to, my lord. Allegation is that, my lord, the petitioner here in, my lord, apart from helping accused number 1 to administer the poison, had also compressed the neck of the, my lord, deceased.
The claim report says cardiopulmonary arrest as a result of
Unknown compound poison with evidence of
pressure
pressure.
over neck.
Okay. And my lord, the only, my lord, change of circumstances, my lord, is argued by the petitioner is, my lord, that she is suffering from medical ailments, my lord. But, my lord, the jail authorities, my lord, have not filed any report, my lord, stating that she has undergone any medical complications, my lord, after being remanded to custody. And, my lord, the trial court, my lord, also, my lord, will,
No, whether in the present petition, the medical ground has been taken,
my lord, it has been taken, my lord.
which paragraph?
Trial court, my lord, it was taken.
No, here it's not taken.
My humble submission is, my lord, the only change of circumstances is, my lord, they
Filing of charge sheet.
filing of charge sheet, my lord. Filing of charge sheet, my lord, goes against, my lord, the petitioner, my lord, wherein the statements of, my lord, the eyewitness reflects the overtax of the petitioner hearing. And moreover, my lord, the petitioner as well as the accused, my lord, belong to the same village, my lord.
Have you anywhere in your objection apprehended about the tampering of, possibility of tampering of the witnesses before trial? Hmm. Please be seated. For 39 petition formatted. The present petitioner is accused number 8 in crime number 12/2022 of Yadgiri Rural Police Station, which crime was originally registered for the offences punishable under sections 341, 323, 504, 506. That is section 149 of the Indian Penal Code 1860 brevity IPC. However, during the course of investigation, section 302 of IPC was also incorporated. After completion of the investigation, the police have filed charge sheet. against 12 accused, including the present petitioner, for the offences punishable under section 341, 323, 504, 506, 302, read with section 149 of Indian Penal Code. The summary of the case of the prosecution is that on the date 31/2022, the parents of the complainant and uncles of the complainant together went to the house of accused number 1, Mannu alias Manohar, to have a negotiation and talk about the partition of the alleged ancestral property. According to the complainant, the accused number 1, Mannu alias Manohar, was said to be in the house. Apart from refusing to talk regarding the partition of the property, is also said to have denied his relationship with the complainant's family and abused the complainant's family in filthy language and threatened them of taking away their life. It is further the case of prosecution that being annoyed by the said incident, it is further the case of the prosecution that the complainant, who is said to be the son of deceased Shanti Bai, in his complaint stated that being annoyed by the said incident, his mother consumed poison. Accordingly, initially, a case came to be registered against 7 accused persons for the offences punishable under section 341, 323, 504, 506, read with section 149 of Indian Penal Code. After the alleged incident of this is Shanti Bai said to have been under the influence of poison, she was admitted for treatment. However, it is reported that she died on 3/2/2022 while under treatment. Very next day, that is on 4/2/2022, the very same complainant is said to have given his further statement before the police, stating that on the date of the incident, his mother was forcibly administered poison by the accused persons. However, on the date of incident, since he was in grief in his complaint, he had only stated that his mother has taken poison, and which complaint was in the form of a oral statement before the police. It is based upon his further statement after the police incorporated section 302 EPC also in the matter and proceeded with the investigation, finally ending in charge sheet in 12 accused for the above said offences, including section 302 Indian Penal Code. Yeah. The learned HCGP appearing for the state who is physically present today has filed a statement of objection wherein he contends that in this successive bail petition, the petitioner has not made out any change in circumstance and the grounds made out is not sufficient to enlarge on bail. It is further contended that since the complainant himself is eyewitness to the incident and the post-mortem report also corroborates the case of prosecution, it's not a fit case where the accused number 8 oblique petitioner deserves to be enlarged on bail. In his argument also, the learned CGP reiterated the same grounds of objections and submitted that there is no change in the circumstance. He also mentioned that the main person who forcibly administered poison to deceased Shanti Bayi is none else than the present petition. The learned counsel for the petitioner, who is appearing through video conference, in his argument submitted that there are greater variations in the statement of the complainant given at different times before the investigating officer. He submitted that the very statement of CW1 does not inspire any confidence even to prima facie believe about its contents. He also submitted that in view of an admittedly there is tendency of a civil litigation between the deceased and the accused, between the family of the deceased and the present petitioner regarding the partition of the ancestral property. It is because of the civil litigation, in order to discourage the accused in the matter and their family members, a false criminal case has been hoisted, alleging the administration of poison to the deceased. He also submitted that though this is the second successive bail petition of the petitioner, however, the earlier petition was rejected only on the ground of investigation being in progress. Now, since the investigation has long back been completed and petitioner is in judicial custody for more than a year, the petition deserves to be allowed. A reading of the entire charge, a perusal of the charge sheet paper placed before this court in the form of copies as annexures to the petition would go to show that with respect to an alleged dispute regarding the sharing of the family properties, the alleged incident is said to have taken place. The complainant is shown to have stated that the family of the accused, apart from denying giving any share in the property, is also said to have denied the alleged relationship between the family of the deceased with the family of the accused. A careful reading of the complaint shown to have been given by Vansri Akash, said to Vansri Akash, claiming himself to be the son of deceased Chandibai alias Chandrakala, and his alleged further statements shown to have been given before the police on 4/2/2022 would go to show that in his first complaint before the police, based upon which a crime number 12/2022 came to be registered with the respondent police, the complaint is shown to have stated that being annoyed by the abusive words of his uncle, that is accused number 1, and the refusal by the accused of sharing the family property with the deceased and her family, his mother, bracket with the deceased, consumed poison. Accordingly, the crime was registered for the offences punishable under section 341, 323, 504, 506, read with section 149 IPC. However, the very same witness in his alleged further statements shown to have been given on 4/2/2022 before the investigating officer has stated that he was an eyewitness to the incident and that the accused, apart from abusing the deceased and her family and manhandling them, also forcibly administered poison to the mother of the complainant. It is the complaint is shown to have specifically stated that it was accused number 1 who held his mother with her hands and asked others to bring poison. Accordingly, the poison was brought from by the other accused. At that time, it was the present petitioner, bracket accused number 10, who forcibly administers the poison to his mother. There are no doubt a reading of the further statement of the complainant prima facie go to show that being the son of the deceased, he must have seen the incident as contended by him and has given a complete account about the incident. However, his further statement is not the only statement given by him before the police. Admittedly, his first statement before the police is dated 31/2022, which is shown to have been given by him to the police on the very same day of the alleged incident. That too without wasting of. That too within 1.5 to 2 hours after the incident. In the said first statement, which was stated as first information to the police, there is no whisper about anyone of the accused, much less the present petitioner, forcibly administering poison to the mother of the complainant, that is deceased Shanti Bai. On the other hand, in the said complaint, it is shown that the complainant has stated that being annoyed by the ill treatment meted to her, the deceased, herself consumed poison. At this stage, the above variation in the first statement of the complainant was considered as a complaint before the police, and his further statement, a greater and material variations can be found. His further statement that the poison was forcibly administered to her mother, to his mother, by accused number 1 and 8, joined by other accused. Prima facie and at this stage appears to be a material improvement made by the complainant. A natural doubt arises at this stage that had really CW1, had really the complainant, Akash, been an eyewitness to the incident, what had prevented him from disclosing before the police at the earliest point of time about the alleged administration of poison by the accused, more particularly by the present petitioner, bracket accused number 8. The reason given by the complainant in that regard about he not revealing the alleged fact of administration of poison to his mother requires to be analyzed and assessed in a full-fledged trial. As such, at this stage, neither his statement of not mentioning the alleged administration of poison in his complaint before the police can be considered as a material improvement and intentionally introduced as an afterthought, nor it can be accepted as a true fact. As such, no observation can be made on the said aspect at this stage. However, the fact remains that though CW1 Akash had every opportunity to, so though CW1 Akash, who claims himself to be an eyewitness, and also the son of the deceased had every opportunity and occasion to reveal the alleged entire facts before the police, when he himself has not stated about a material aspect of the alleged incident, which is an alleged act of administration of poison, it cannot be straightaway taken at this stage for the purpose of disposing of this petition under consideration that the complainant had every valid reasons for not to mention the same before the police. Such a circumstance, when a primary eyewitness's statement is at some variation, it cannot be held that none else than it cannot be held at this stage that what are all CW1 has stated in his further statement are all fully true. As such, the benefit of the same for the time being is required to be given to the petitioner herein, however, subject to the outcome of the trial. In addition to the above, it's also not known of the fact that the very same complainant in his further statement dated 4/2/2022 has stated he has mentioned about two more eyewitnesses. Who are they?
My lord, in the complaint,
Devi
it is mentioned. In the complaint, my lord.
That is in the
Sakshi
complaint.
Bai.
Sakshi Bai, Devi Bai.
My lord, another, my lord, Devi Bai Ganda Pol Singh, my lord.
The very same complainant in his further statement, in his complaint dated 31/2022 has stated that the incident was also witnessed by his auntie Sakshi Bai and one Srimati Devi Bai. However, both those alleged eyewitnesses are not shown as charge sheet witnesses. Maybe the investigating officer might have reasons for omitting them from showing as charge sheet witnesses. Still, the fact remains that both Sakshi Bai and Devi Bai were shown as eyewitnesses to the incident by none else than the son of the deceased, who also claims himself to be an eyewitness to the incident. This aspect also seems required to be considered during the course of the full-fledged trial. And also considering the fact that the present petitioner is said to be in judicial custody since the date 8/2/2022, that is for more than a year, and investigation admittedly has already been completed, I am of the view that imposing reasonable conditions, the petitioner be enlarged on bail. The apprehension of the prosecution that in case the petitioner is enlarged on bail, there is likelihood of she being the resident of the same village of the deceased, tampering with the prosecution witnesses, can be checked by imposing reasonable conditions. Accordingly, I proceed to pass the following order. The petition stands allowed ಅದನ್ನೆಲ್ಲ ಹಾಕಿ 439 conditions ಹಾಕಿ 50,000 rupees personal bond with the 2 solvent sureties to the satisfaction of the trial court where the matter is pending now. ಆಮೇಲೆ ಬೇರೆ conditions ಹಾಕಿ not to hamper, tamper, to appear before the court on all the dates of hearing, to submit in writing to the court and to obtain acknowledgement regarding the change in the address during the pendency of the trial, and to abide by the further orders to be passed by the court. No. Yeah.
Much obliged.
Case number 38, Ravi Shankar.
And again in the afternoon, learning counsel for the appellant, who is physically present, files a memo seeking dispensation of notice. The respondent number 2. Memo allowed or to dispense with. Viram General who's
Sriram General Insurance Company retired.
process strategy ತಗೊಳ್ತೀರಿ ಶಿವನೇಗೌಡ learned counsel Sri B.C. Shivanegowda, who is physically present, accepts the notice for respondent number 1. Copy ಕೊಟ್ಬಿಡಿ. ಕೈಲಿ ಕೊಟ್ಟಿರಿ ಆಮೇಲೆ ಹೊರಗಡೆ ವಾಪಸ್ ಅವ್ರು ತೆಗೆದು ಕೊಡ್ತಾರೆ, ಕೊಡಿ ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಡಿ ಸರ್. Acknowledges the receipt of the copy of the memorandum of appeal along with copy of IA 1/2020 and annexures. He prays for 2 weeks time to file wakalat and to file statement of objection if we need to IA 1/2020. The time as prayed for is granted. Call for TCR. Yes.
Bill number 58, Sri Prasanna Vihar, Sri Mook Mahesh for auto.
You have muted your microphone, Mr. Mahesh. Yes, it is your matter now. Serial 58.
58.
Prasanna, we are in the post.
Sri Prasanna Vihar, retired.
Learned counsel for the appellant, neither present physically nor through video conference. Learned counsel for respondent number 2 alone is appearing through video conference. Here is the memorandum of appeal. Call for TCR. Just the matter immediately after ensuing summer vacation.
Please.
Bill number 62, Sri Gurra Shetty K, PV Raju for auto.
Please be seated. Claimant's appeal for enhancement of compensation. The summary of the case of the claimant before the tribunal was that on 19/7/2014 at about 9:30 a.m. by the claimant along with one Sri Kamala, who is also a claimant in NEC number 803 of 2014, were walking on the side of a road leading from Ampar to Kundapura, and when they were near Sugar Cross Road at Amparu village, a Maruti Swift motor car bearing registration number KA25N8706, being driven by its driver in a rash and negligent manner and coming from Amparu side, dashed to the claimants, due to which road traffic accident, both the present claimant and Srimati Kamala sustained injuries. According to the claimant, she was shifted to Chinmaya Hospital, Kundapura for first aid treatment, and then to Adarsha Hospital, Udupi, where she has taken treatment as an inpatient from 19/7/2014 to 17/8/2014. She has also stated that she underwent a surgical operation and still not recovered from the injuries. She has further stated that she was working at the time of road traffic accident, she was working as a coolie and earning a sum of ₹9,000 per month. However, due to the injuries suffered by her, she is now disabled to pursue her avocation. With this, she has claimed in total a compensation of a sum of ₹15,50,000 from the respondents number 1 and 2, arraigning them as the owner and insurer of the alleged offending motor car, respectively. Though the notice was served upon both the respondents, however, it is only the respondent number 2 which filed its statement of objection, wherein it denied the occurrence of the road traffic accident in the manner as alleged by the claimant. It specifically denied that the claimant sustained the injuries in the accident, much less the one that are depicted by the claimant. Further, denying the age, income, and avocation and the alleged disability of the claimant, the respondent number 2 prayed for rejection of the claim petition. Within the lucky table, occurrence of the road traffic accident may not be not in dispute because it is the claimant's petition for enhancement of their. Further, the claimant got herself examined as PW1, where in her examination, chief has reiterated the contention taken up by her in her claim petition regarding the occurrence of the road traffic accident, manner of its occurrence, the injuries sustained by her, and also about her alleged disability. In support of her contention, apart from examining one Dr. Dinesh Kumar and Dinesh Kumar Shetty, an orthopedic surgeon as PW2, she also got produced and marked documents from exhibits P1 to P10, which inter alia includes the copies of the complaint, FIR, wound certificate, scene of offense Panchanama, motor vehicle inspection report, rough sketch of the spot, charge sheet, disability certificate. These documents corroborate the evidence. The only question that remains for consideration is regarding the quantum of the compensation awarded. The counsel for the appellant in his argument submitted that the claimant has sustained multiple injuries and was treated as inpatient in the hospital for a considerable length of time. As such, the quantum of compensation awarded under all heads, including first pain and suffering, is on the lower side. He further submitted that even though the claimant has not produced any documentary proof about her income, still the tribunal was required to take the notional income of rupees 8,500 per month, which was prevailing for the relevant year. However, the tribunal has considered a lower sum as the notional income. With this, he submitted that the appeal deserves to be allowed. As observed in the order sheet dated 19/4/2023 in detail, the learned counsel for the respondent number 2 insurance company who had accepted the notice for the respondent number 2 company has neither appeared and addressed his argument in the matter, nor even has filed his wakalat in the matter. As such, it was taken that the respondent number 2, though was served, has not proceeded in the matter. Next slide. The evidence of PW1 that in the accident she sustained multiple injuries is further corroborated by the wound certificate at exhibit P2. PW2. And also by the evidence of PW2, the doctor who has clinically examined the claimant. The wound certificate as well the evidence of PW2 reveals that in the road traffic accident, the claimant sustained one trochanteric fracture right hip, right hip, 2 laceration on the right ankle measuring 10 into 6 centimeter. Laceration on the forehead measuring 4 into 2 centimeter. The injury number 1 was opined as grievous and other 2 injuries were opined as simple in nature. According to PW2, the claimant was admitted in their hospital from 19/7/2014 to 23/7/2014. And she was treated with conservative methods, skin traction. Thus, the petitioner must have suffered considerable pain for the injuries sustained by her. Since it is considering these aspects, since it is considering the injuries and sufferings suffered by the claimant, the tribunal has awarded a compensation of the sum of rupees 30,000 towards the pain and suffering. I do not find any reason to modify the same. Fair. The claimant has PW1 to depose that she has incurred a sum of rupees 40,000 towards medical expenses. However, she could be able to produce the medical bills worth a sum of rupees 12,792 only. It is after taking into consideration those medical bills produced by the claimant at Exhibit P10, since the tribunal has awarded a sum of rupees 12,792, which were the actuals, and also considering a stay in the hospital and requirement of attendant and the special diet, has awarded another sum of rupees 3,000 and 2,000 towards them respectively, which in total has come to rupees 17,790. I do not find any reason to enhance the said amount. The claimant has contended that at the time of accident, she was working as a coolie and was earning a sum of rupees 9,000 per month. Admittedly, except her self-serving oral statement, there is no other piece of evidence, including any documents, to corroborate her evidence regarding the income. As such, the tribunal has decided to take the notional income of the claimant for the relevant year. However, in the said process, it has taken the income of the claimant as at rupees 6,500, when in fact for the relevant year, that is 2014, a large number of motor accident claims tribunal in the state were taking rupees 8,500 as the notional income. Thus, the income of the claimant for the relevant period is required to be taken at rupees 8,500. Towards loss of income during the laid-up period, which laid-up period according to the tribunal was 5 months. It has awarded a sum of rupees 32,500, computing at the rate of rupees 6,500 per month. In view of the fact that now the notional income of the claimant is taken at an enhanced amount of rupees 8,500 per month, which is rupees 2,000 higher than what the tribunal had taken earlier, the claimant is entitled for the differential amount of rupees 2,000 into 5 months equals rupees 10,000 as the enhancement under the said head. Okay. Next line. The claimant has contended that due to the injuries sustained by her in the road traffic accident, she is unable to continue her vocation. In her support, apart from producing a disability certificate shown to have been issued by PW2 and getting it marked at exhibit P8, We also got examined the said Dr. Dinesh Kumar Shetty, an orthopedic surgeon at Chinmay Hospital, Kundapura, as PW2. The said witness has stated that due to the injuries suffered by her in a road traffic accident, the claimant was admitted and treated in their hospital as inpatient. Claimant to have gone through the medical records and clinically examining the injured, the doctor has opined that the claimant was suffering with a disability of 12% to her right lower limb. The tribunal has taken the percentage of disability as applicable to the whole body at 8%. Though the learned counsel for the appellant contended that the tribunal ought to have taken the percentage of disability to 12% only, I am of the view that since they said 12% disability was confined into a particular right lower limb of the claimant, the tribunal was justified in confining the said percentage of disability at 8% as applicable to the whole body of the claimant. The wound certificate at Exhibit P2 shows the age of the claimant as at 40 years as on the date of the road traffic accident. As such, the standard multiplier applicable is 15. Thus, the quantum of compensation towards loss of a future income or disability would come to rupees 8,500 into 12 into 15 into 8 by 100 equals rupees 1,22,400. After deducting a sum of rupees 93,600 awarded by the tribunal under the said head, the claimant is entitled for the differential amount of rupees 28,800 as enhancement. Towards loss of amenities, the tribunal has awarded a compensation of a sum of rupees 12,000. Considering the nature of the injuries, the organ of the body with which suffered the said injury, the alleged avocation of the claimant, and the circumstance of the case, I am of the view that the said quantum of compensation awarded deserves to be enhanced marginally by another sum of rupees 8,000, thus making it in total a sum of rupees 20,000. Barring the above, thus in total, $46,800 enhancement. Since the enhanced amount is not with the Lahaki rate of interest applicable body. Since the enhanced amount is not a huge amount, the entire enhanced amount is ordered to be released in favor of the claimant in accordance with law and after due identification. However, after depositing of the said amount by the respondents, as per the order of the respondents, as ordered by the tribunal. The respondents who are liable to deposit the amount as per the impugn judgment and award. Amel rest of the order of the tribunal regarding so apportionment or release or the yes, please.
This number 804, my lordship.
804. ಈಗ ಇದು ತಗೊಂಡಿದ್ದು 804. 803 ಬಂದಿದ್ದು ಕಮಲ ಅಲ್ಲ. ಅದೇ ರೀತಿ ಬಂದಿದೆ ನೋಡಿ. ಬಿಗಿನಿಂಗ್ ಅಲ್ಲೇ ಬರ್ತದೆ ನೋಡಿ. ಅಲಾಂಗ್ ವಿತ್ ಅನದರ್ ಕ್ಲೈಮೆಂಟ್ ಶ್ರೀಮತಿ ಕಮಲ ಇನ್ NEC 803. Yes.
Bill number 54, Sri S. Rajshekar, S. Krishna Kishore for R3.
Query for appellant, my lord. Case of an injury, my lord, seek for enhancement of compensation. For insurance, sir.
Your lordship, my lord. 63, my lord, is it urgent, my lord?
63 ಅವ್ರು ಬೆಳಗ್ಗೆ ಯಾರೋ ಟೈಮ್ ತಗೊಂಡ್ರಲ್ರಿ ನೀವು 2:30 ಹೇಳಿದ್ರಿ ಆಮೇಲೆ ಮತ್ತೆ ಮೂವ್ ಮಾಡಿದ್ರು ಅಪೆಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಚೇತನ್ ಬಿ.
They didn't inform me, my lord. That's why I was waiting.
The court asked him to inform you. He said he undertook that he would inform you. Understood. Adjourned by 2 weeks.
Please.
Yes, please.
Lord, seeking for the enhancement of the compensation under 7 heads. One is for pain and sufferings, conveyance charges, food and nourishment, loss of earning during the treatment, loss of future earning capacity and future medical expenses, and loss of marriage. The tribunal has awarded the
ಈಗ ಎಷ್ಟು ಮಕ್ಕಳು ಕ್ಲೈಮೇಟ್ಗೆ ಕ್ಲೈಮೇಟ್ಗೆ ಎಷ್ಟು ಮಕ್ಕಳು ಇದ್ದಾರೆ ಈಗ?
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ಮದುವೆ ಆಗಿಲ್ಲ ಆಗಿತ್ತು ಮೇಡಮ್.
ಎಸ್
Total pain and suffering, they have awarded a compensation of 75,000, but the petitioner has undergone the operations and tribunal, without considering the facts and the wounds which has been suffered by the petitioners, by the appellant, they have awarded the 75,000. They seek for the enhancement of the compensation under this side. And second is that they have compensation awarded under conveyances 10,000 charges, but the petitioner was in hospital for 12 days, and he was asked to take the bed rest of 6 months and he was forced to take the help of the assistant, and he was paid rupees 200 per month. And next is that awarded in the loss of income, they have awarded the earning during the treatment was 10,000. The appellant was working in a garage, and his per month salary was around 9,000, and he was in a complete bed rest for the 6 months. But they have awarded the 10,000, and they have taken the salary as rupee. Yes, ma'am. Next is of loss of future earning capacity. In that, they have taken the salary of the appellant as 6,000. But the appellant was the salary of the appellant was 9,000. Even in exhibit P8, the certificate which is issued by the given by the owner of the company, and the deposition made by him in PW7. Even he has stated that. He was giving him the salary of rupees 9,000 per month, and he would not give him any salary if he was absent for the during that period. And this
whether the person who issued this certificate has been examined.
Yes, yes, examined as PW5.
PW
5. Yes. Compensation awarded under the head of the future expenses. It has been given 30,000. Now, looking into the deposition and the disability certificate, he requires the implantation of 25,000, which of the teeth, which amounts to 25 itself is 25,000. There is a permanent treatment for the eyes and nose, and this has also been stated in the exhibit P8 and the evidence of the PW3 manner.
Yes.
And next is that the compensation awarded in the head of the loss of the marriage prospects in the other side. It has been awarded the 50,000. We see for the enhancement of the compensation as the injuries occur to him is on the face, and there is a permanent disabilities and marks in the face of the body, and so see for the enhancement of the compensation.
Yes.
Yes, my lord.
Yes.
As for disability certificate, my lord, the appellant suffered head injuries and facial injuries. He was treated for the same. My lord, exhibit P7, disability certificate, my lord. After perusal of wound certificate, case sheet, physical and radiological examination, we are of the opinion that he has a permanent physical disability of 11% in the face, 10% with regard to whole body to smell. He may require implant removal, which may cost rupees 25,000 in AJ Hospital and Research Center, where he took treatment. Alle further implant removal, 25,000 ಕೊಟ್ಟಿದ್ದಾರೆ. Lord, with regard to avocation and income, Lord, though PW 5 was there, examined in support of the claim of the appellant, no parallel document is produced by him to show that he was giving 9,000 rupees to the appellant. Cross examination ನಲ್ಲಿ ಅವರನ್ನೇ ಒಪ್ಪಿಕೊಳ್ಳುತ್ತಾರೆ. ಅರ್ಜಿದಾರ 2007ರಲ್ಲಿ ನನ್ನ ಬಳಿ ಮೆಕ್ಯಾನಿಕ್ ಆಗಿ ನೇಮಕೊಂಡಿದ್ದ ಮತ್ತು 2012ರಲ್ಲಿ ಇಶ್ವಿನಲ್ಲಿ ಅದು ಕೆಲಸ ಬಿಟ್ಟ. ನಾನು ಕೊಟ್ಟಿರುವ ಸರ್ಟಿಫಿಕೇಟ್ ನಲ್ಲಿ ಅರ್ಜಿದಾರರನ್ನು ಯಾವಾಗ ನೇಮಿಸಿಕೊಂಡಿದ್ದೆ ಮತ್ತು ಯಾವಾಗ ಅದನ್ನು ಸೇವೆಯಿಂದ ಕೈಬಿಟ್ಟೆ ಎನ್ನುವ ಬಗ್ಗೆ ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಬರೆದಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಅದೇ ರೀತಿ ಮಾಸಿಕ 20,000 ರೂಪಾಯಿ ವೇತನ ಒಟ್ಟು ನನ್ನ ಬಳಿ ಯಾವುದೇ ವೇತನ ದಾಖಲಾತಿ ಇಲ್ಲ. ಆದರೆ ವೇಜ್ ಸ್ಲಿಪ್ ನನ್ನ ಬಳಿ ಇದೆ. ಯಾವುದೇ PF ಮತ್ತು ಗ್ರಾಚ್ಯುಟಿ ಕೊಡುವ ಪದ್ಧತಿ ನಮ್ಮ ಬಳಿ ಇಲ್ಲ. 9,000 ರೂಪಾಯಿ ತಿಂಗಳು ಕೊಡುತ್ತಿದ್ದವು, ಆದ್ರೆ ರಜಾ ದಿನಗಳಲ್ಲಿ ಸಂಬಳ ಕೊಡ್ತಿರ್ಲಿಲ್ಲ. ಆ ರೀತಿ ನನ್ನ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಬರೆದಿಲ್ಲ ಎಂದ್ರೆ ಸರಿ. ಭಾನುವಾರ ಹೊರತುಪಡಿಸಿ ಉಳಿದ ಎಲ್ಲಾ ದಿನಗಳಲ್ಲಿ ನಾನು ಸಂಬಳ ಕೊಡುತ್ತೇನೆ. ಒಂದು ವೇಳೆ ರಜಾ ಮಾಡಿದರೆ ಆ ದಿನದ ವೇತನವನ್ನು ಕಟಾವು ಮಾಡ್ತೇನೆ. ಅರ್ಜಿದಾರ ನನ್ನ ಸಹಿತ ಎಂದರೆ ಸರಿ. ಅದಕ್ಕೋಸ್ಕರ in the absence of proof of income, 6,000 is great. Lord, since the accident occurred in the year 2011, as per chart prepared by Karnataka State Level, 6,500 has to be taken into consideration. In all other heads, my lord, substantially it is awarded.
Enhancement of compensation injury. Summary of the case of the claimant before the tribunal was that on the date 22/9/2011, while he was traveling as a pillion rider on a motorcycle bearing registration number KA21K6248, being ridden by one Sri Santosh. That is the first respondent. And were going on Mangalore-Bengaluru National Highway 75 and approached a place called Nelliyadi near Santekatte, Puttur Taluk. Due to the rash and negligent riding of the motorcycle by its rider, it dashed against a pedestrian, a boy, and by losing the control, it got capsized, resulting into a road traffic accident. In the said road traffic accident, he, claimant, sustained multiple grievous injuries on his head, face, forehead, right shoulder, right knee, and all over the body. He was shifted to Asia Hospital and Research Center at Mangaluru for treatment and was treated for a long duration by several specialist doctors. Towards medical expenses, he has spent not less than a sum of rupees 2 lakh rupees and expecting another sum of rupees 50,000 towards future medical expenses. He has incurred expenditure of about rupees 50,000 towards the traveling, food, and other incidental expenses. He has also stated that at the time of accident, he was working as a mechanic at Hero Honda service station at Nelliyadi, Puttur Taluk, and earning a monthly income of rupees 9,000 per month. However, due to the road traffic accident and the disability suffered by him, he could not continue his job. With this, he has claimed a compensation of a sum of rupees 10 lakh, holding the respondent number 1, 2, 3 as the driver, owner, and insurer of the alleged offending motorcycle liable to pay compensation to him. In response to the notices served upon them, it was only the respondent number 3, the insurance company, which appeared through its counsel and filed its statement of objection, wherein it has denied all the petition averment, including the alleged road traffic accident occurring in a manner as contended by the claimant. It also denied the nature of injuries said to have been suffered by the claimant, further denying the age, income, and occupation of the claimant and his alleged disability. The respondent number 3 has prayed for rejection of the claim petition. Munindala Haki, table occurrence of road traffic accident is not in dispute. Further, the claimant got himself examined as PW1, who in his examination in chief in the form of affidavit evidence has reiterated the contention taken up by him in his claim petition about the occurrence of a road traffic accident. He also got produced documents from exhibits P1 to P48, which inter alia includes the copy of the complaint, copies of the complaint, FIR, scene of offense Panchanama, sketch wound certificate, and a disability certificate. These documents, disability certificates, and a discharge summary. These documents corroborates the evidence of PW1 about the occurrence of the road traffic accident on the date, time, place, and in the manner as contended by him in his claim petition. The evidence of PW1 about his sustaining injuries in the accident is corroborated with the wound certificate at Exhibit P6. The same is further corroborated by the evidence of Dr. Sunil Shetty, Dr. Ullas Shetty, and Dr. Dinesh Kadam, who were examined by the claimant as PW2, PW3, and PW4 respectively. Therefore, the occurrence of the road traffic accident on the date, time, and place and in the manner as contended by the claimant in his claim petition and the claimant sustaining multiple grievous injuries in the said road traffic accident stands established. Hence, the respondent number 1, 2, and 3 being the driver, owner, and insurer of the offending motorcycle bearing registration number KA21 K6248 are jointly and severally liable to pay compensation to the claimant. Thus, the only point that remains for consideration is regarding the quantification of the compensation. The learned counsel for the appellant in his argument submitted that the injuries and the injuries and their nature go to show that the claimant has sustained multiple simple and grievous injuries, and he has also treated as inpatient for a long time in the hospital. As such, the quantum of compensation awarded towards pain and suffering is meager and deserves to be enhanced. He further submitted that the income of the claimant, which he has stated at 9,000 rupees per month, is further corroborated by the evidence of his employer, who was examined as PW5, and the salary certificate produced and marked by the claimant at Exhibit P8. Since there being no reasons to disbelieve the same, the tribunal ought to have considered the income of the claimant at rupees 9,000 per month. Further stating that the compensation awarded under other heads are also meager, the learned counsel for the appellant prayed to allow the appeal. Per contra, learned counsel for the respondent number 3, the insurance company, in his argument submitted that even though considering the fact that the claimant has sustained multiple grievous injuries, the tribunal has awarded a reasonable and just compensation of rupees 75,000 towards pain and suffering. As such, the same does not warrant any modification by this court. He also submitted that the compensation awarded under other heads are in no way less than the actuals and reasonable. As such, they do not warrant any interference at the hands of this court. He further submitted that the income of the claimant, though claimed to be rupees 9,000 per month, however, the same has not established by him. Even though PW5 has been examined as the author of salary certificate at Exhibit P8, but admittedly, the said witness has not produced any salary registers or other documents. As such, the notional income prevailing for the relevant year is required to be taken. However, he considered himself that though the tribunal has taken the notional income as at rupees 6,000, the same is, since being short by rupees 500 per month, deserves to be enhanced by a sum of rupees 500 and to be taken at rupees 6,500 per month. With this, he submitted that the appeal doesn't deserve to be allowed as prayed. The claimant as PW1 has stated that in the road traffic accident, he sustained multiple grievous injuries. In his support, he got examined 3 medical doctors. In his support, he got produced the wound certificate at Exhibit P6, the discharge summary at Exhibit P10, and also got examined 3 doctors as from PW2 to PW4. PW2 is a neurosurgeon who has spoken about the examining the claimant and noticing the injuries sustained by him in the road traffic accident. PW3, Dr. Ullas Shetty is a medico-legal consultant and working at Asia Hospital and Research Center, Mangaluru, and has stated about the claimant being treated in their hospital as inpatient. He too, after relying upon the medical documents maintained by his hospital, has given the details of the injuries sustained by the claimant in the road traffic accident, and also has assessed the percentage of disability with which the claimant was said to be suffering with. PW4, Dr. Dinesh Kadam, a plastic surgeon and working at Asia Hospital and Research Center, Mangaluru, also has stated about the claimant taking treatment in their hospital, and he too examining the claimant and assessing the disability. The opinion of all these three doctors, that is PW2, PW3, and PW4, corroborates the injuries described in the wound certificate and mentioned in the discharge summary at Exhibit P10. Accordingly, the claimant is established to have sustained the following injuries. ಇದು ಎಕ್ಸಿಬಿಟ್ P7 ನಲ್ಲಿ ಇದೆ. P10 ನಲ್ಲಿ Exhibit P7 alide injury number 2 in the haki lacerated wound 5 centimeter into 1 centimeter. Allinda hemorrhagic contusions in bilateral frontal lobes. Annalli varaga the discharge summary at Exhibit P10 issued by Asia Hospital and Research Center, Mangaluru, shows that the claimant was admitted as inpatient in their hospital on 22/9/2011. Discharge date ಎಲ್ಲಿದೆ ರೀ ಇದರಲ್ಲಿ? Discharge summary ಎಲ್ಲಿ? Discharge date ಎಲ್ಲಿದೆ? ಇಂಥ ತಾರೀಕು ಡಿಸ್ಚಾರ್ಜ್ ಆದ ಅನ್ನೋದನ್ನ ನಂಬಲಿಕ್ಕೆ ಇರ್ತಕ್ಕಂಥ ಡಾಕ್ಯುಮೆಂಟ್ ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿಯ ವುಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್. ಡಿಸ್ಚಾರ್ಜ್ ಸಮ್ಮರಿಯಲ್ಲಿ ಕೇಸ್ ಹಾಕಿರೋದು ಅವರಲ್ವೇ, ದುಡ್ಡು ಜಾಸ್ತಿ ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಳ್ತಿರೋದು ಅವರಲ್ವೇ, ಅಟ್ಲೀಸ್ಟ್ ಅವ್ರಿಗೆ ಆ ಸಣ್ಣ ಜವಾಬ್ದಾರಿ ಬೇಕಲ್ವೇ, ಯಾವಾಗ ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದೆ ಅನ್ನೋದನ್ನ ಹೇಳ್ಬೇಕು ಅಂತ. ದುಡ್ಡು ಜಾಸ್ತಿ ಕೊಡಿ ಅನ್ನೋದು ಬಿಟ್ಟು ಬೇರೆದೇನು ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡಲ್ಲ. The wound certificate issued by the same hospital go to show that he was discharged from the hospital on 4/10/2011. Thus, For about 12 days, he was treated as inpatient in the said hospital. Hence, considering the multiple grievous injuries and also the simple injuries which are large in number, though the tribunal has awarded a compensation of a sum of rupees 75,000 under the said head, I am of the view that the same deserves to be enhanced by a sum of rupees 20,000 to make it a reasonable amount. Fair enough. The medical expenditure incurred by the claimant is corroborated by the medical bills from Exhibit P11 to Exhibit P43, medical prescriptions, 23 medical prescriptions at Exhibit P44. The case sheet at Exhibit C1. It is considering these aspects, the tribunal has arrived at the actual amount of rupees 2 lakh as the expenditure incurred by the claimant and awarded the same towards medical expenses. The same does not warrant any interference at the hands of this court. It is after considering that the claimant was inpatient in the hospital for 12 days, the tribunal has awarded a compensation of rupees 10,000 towards conveyance charges. For no reasons, the said amount can be considered as a lower amount. Hence, it deserves no modification. Towards food, nutrition, and nourishment, the tribunal has awarded a compensation of rupees 5,000. Considering the nature of the multiple grievous injuries he sustained, for which a special diet and limited varieties of foods might have been prescribed for him, and also the requirement of the attendant to attend him for his stay in the hospital, I am of the view that the compensation of rupees 5,000 awarded by the tribunal deserves to be enhanced by a sum of rupees 10,000, thus making it in total to a sum of rupees 15,000. The claimant has contended Kutkali that at the time of accident, he was working as a mechanic in a Hero Honda motorbike service center and was getting a salary of a sum of rupees 9,000 per month. In that regard, he got produced a document calling it a salary certificate at Exhibit P8 and examined one Shri Naresh, who is said to be the author of the said document at Exhibit P5. Said PW5 in his evidence has stated that for the past several years he has been running a motorcycle care and service center under the name and style Messrs. Kirti Bike Care, engaging the services of 4 mechanics, including the present claimant. He has stated that the present claimant was an experienced mechanic. As such, he was giving him a salary of rupees 9,000 per month. He stated that till the date of the road traffic accident, the claimant was attending to his work. However, after the accident, he has stopped coming to the work. In his cross-examination, he has stated that he is not maintaining any register of employment. He also stated that he was giving the salary to the employees only for the days on which they attend to their work and was not giving the salary for the holidays. He has identified that the salary certificate at Exhibit P8 is issued by him. Thus, in his cross-examination, though attempts were made to shake the credibility of the evidence of PW5, but the respondents could not able to do it completely and successfully. Therefore, considering the evidence of PW5 and his statement that for the holidays the employees were not getting their salary, I am of the view that though the prevailing notional income for the relevant year 2011 was at 6,500 per month, but there are all the evidence and material to take the income of the claimant in the instant case as at rupees 8,000 per month. 8,000 per month. Para. When the income of the claimant is taken at rupees 8,000 per month, the quantum of compensation awarded by the tribunal towards loss of earning during treatment period, which is at rupees 10,000, and without mentioning as to for how long a period the claimant has sustained the loss of income, requires a revisit. The tribunal accepts stating that the claimant must have taken rest and laid down for several months, has, without any calculation, awarded a lump sum of rupees 10,000 as compensation towards loss of earning during treatment. Considering the facts and circumstances of the case, I am of the view that considering the facts and circumstances of the case, more particularly the multiple grievous injuries, including not less than 7 fractures on the different parts of the body, including the head and face, I am of the view that the claimant must have advised and taken rest minimum for a period of 5 months. Accordingly, towards loss of income for a period of 5 months, he is entitled for compensation at rupees 8,000 into 5 equals 40,000. After deducting rupees 10,000 awarded by the tribunal, he is entitled for the differential amount of rupees 30,000 as enhancement. The claimant has stated that due to the injuries sustained by him in the accident, he is suffering with permanent disability. As such, he could not continue his avocation. In this regard, he has got PW3 and PW4, the medico-legal expert and plastic surgeon, to lead their evidence, who have assessed the disability of the claimant and given their evidence. The sum and substance of their evidence, though, shows that the claimant was suffering with physical disability due to the injuries sustained by him in the road traffic accident. And assessed the permanent disability at 11% in face, and with respect to the whole body at 10%, the tribunal has accepted their assessment as their assessment as to the percentage of disability to the whole body as at 10%, retaining the same percentage of disability for the age of the claimant, which is shown to be 28 years in the medical records, for which the multiplier applicable is 17, the quantum of compensation towards the loss of a future income would be at rupees 8,000 into 12 into 17 into 10 divided by 100 equals rupees 1,63,200. After deducting a sum of rupees 1,22,400 awarded by the tribunal, the claimant is entitled for the differential amount of rupees 40,800 as enhancement. Next time, it is considering the evidence of PW3 and Exhibit P7, where the expected future medical expenses is said to be 25,000. The tribunal has awarded rupees 30,000 under the said head, which is rupees 5,000 more than the medical evidence. The same does not warrant any further enhancement. Next line. It is after analyzing, it is after taking into consideration the evidence of medico-legal expert and neurosurgeon who were examined as PW3 and PW4, and also considering the evidence of PW1 and the nature of injuries sustained by him and disfiguration of his body, including the face, the tribunal since has awarded a sum of rupees 50,000 as compensation towards the loss of marriage prospectus to the claimant who tells himself to be unmarried, I do not want to enhance the said compensation any further since the same is just and reasonable in the circumstance of the case. Barring the above table, thus in total 1,08,000. ಉಳಿದಿದ್ದೆಲ್ಲದನ್ನು ಅದೇ ಪ್ರಕಾರ ಹಾಕಿ as per the law. For clear. ನಿಮ್ದು ಏನ್ರಿ 68 ಯಾವಾಗ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಗ್ತದೆ 68 learned counsel for respondent number 3 alone present. List the matter immediately after ensuing summer vacation.
Serial number 60.
Learned counsel from both sides present. Since the court time is over, list this matter after ensuing summer vacation.
Serial number 65 minutes. Next matter.
65. Learned counsel for 65. Learned counsel for the appellant is appearing through video conference. None appear for respondents. Since the court time is over, list the matter in the first week of June 2023.